The secular law. From the 15th century and probably earlier, the sacred law, the Sharia, regulated most of the day-to-day affairs of Muslims in the Ottoman Empire, and many aspects too of the lives of non-Muslims. It was not, however, the only legal system in force in the empire, but coexisted also with Ottoman secular law or Kanun. Kanun regulated areas where the provisions of the sacred law were either missing or too much at odds with reality to be applicable. These, in the Ottoman Empire as in other Islamic polities, were above all in the areas of criminal law, land tenure, and taxation. The origins of the secular law lay in custom, and it was long usage that in the first place gave it legitimacy. The late 15th and 16th centuries, however, saw the sultans enact written versions of the law, and modify it through decrees, giving it a dual character of customary and sultanic law. By the 16th century, the consciousness of the disparity between the sacred and the secular law led Kemal Pasha's aide and, later, at royal command, Abu Su'ud to redefine and systematize the Ottoman laws of land and taxation in terms which they borrowed from the Hanafi jurists. 36 In doing this, they were following the tradition of their medieval predecessors who had also sought to explain the reality of feudal tenure and taxation using the terms and concepts of the classical law. 37 Also like their medieval predecessors, what they produced were legal fictions which satisfied pious aspirations, without upsetting legal reality. The basis of Ottoman secular law was the distinction between the Sultan's tax-paying subjects, and his servants who received a salary, either from a fief holding or directly from the treasury. The secular law determined the relationship between these two classes. This was quite different from the distinctions in the sacred law, where it is the classification as male or female, free or slave, Muslim, non-Muslim, subject or non-Muslim enemy that determine a person's legal status, and his or her rights and obligations. In the secular classification of Ottoman subjects, non-taxpayers came to be known as the military askari class. The adjective describes their function more or less accurately, since most members of the class were soldiers, either Timar-holding cavalrymen, or else janissaries and members of the 6 divisions of palace cavalry who received their salaries from the treasury. However, in addition to these men and to the viziers and provincial governors, who served as army commanders, the military class also comprised courtiers in the palace and members of the religious, teaching and legal professions. The general term for a member of the tax-paying class was an Arabic term coming from the sacred law, rayway or, in the plural, riaya, flock and apos. The huge majority of these were peasant cultivators and, in its technical sense, the term rayway referred to a peasant who cultivated a plot of land by virtue of a contractual agreement with the fief holder as representative of the Sultan. In a general sense, the term referred to all Ottoman subjects who were not members of the military class. The formulation of a terminology to describe taxpayers and non-taxpayers is a result of attempts at the end of the 15th century to define their legal status. One of the things that had made this necessary was the establishment of a separate jurisdiction for the military class. This, if we are to believe a story which Spandowns tells us, happened on the order of Bayezid II, 1481-12, and came about, like many institutional changes in the Ottoman Empire, by chance. Spandowns tells us how Bayezid appointed a Sanjak governor as market inspector in Istanbul, in order to provide him with an income while he was out of office. As market inspector, he disobeyed a decree from the judge of Istanbul, Yusuf Kermasti, 1494-8, claiming that, since he received his authority directly from the Sultan, the judge had no jurisdiction. When, after a furious contretemps, the judge tried to prosecute him, no one would give evidence against the market inspector, whereupon the Sultan deprived the said judge of his office, and issued a command that no one should have power and authority over slaves who received a salary from the Sultan, and this command has been observed until today in Apos. Spandowns adds that, now, if anyone has a difference with a Timar holder or a Sabashi, he makes them answer to the Sanjak governor or, if they are in Istanbul, to the Aga of the Janissaries, or to the Pashas, on the Imperial Council in Apos. Bayezid II's decree placing the military class under a separate jurisdiction from ordinary taxpayers required a clear definition of who belonged to which group. The distinction between the military class and tax-paying subjects must have emerged informally in the 14th century with the grant of lands and salaries to the Sultan's followers. The compilation of the cadastral registers from the late 14th century onwards, which recorded revenues and their distribution among Timar holders, provided a record of who belonged to the military class in each Sanjak. They did not, however, provide a legal definition, nor were they comprehensive. In cases of dispute, it was presumably custom and local decision that determined a person's status as taxpayer or military. However, Bayezid's decree placing the military class under a separate jurisdiction made a definition imperative, and it was not long after this that a formulation appeared. The law book issued in 1499 at Bayezid's command defined who belonged to the military class. The cavalryman who serves on sultanic campaigns belongs to the military class, while in service and after retirement, so long as the retired cavalryman is not registered as a taxpayer, ra'iyat, belonging to another person. The sultan's male and female slaves, so long as they are married to one of the military class, themselves, belong to the military class after manumission. Judges, professors, muftis and administrators and supervisors of trusts, that is, holders of offices that are given by attendance at the sultan's exalted threshold, are members of the military class. The following also have military status. A son of a member of the military class, so long as he has a recognized status, and is not registered with anyone as a taxpayer, his wives to whom he is currently married, slaves of a member of the military class, who serve the military class after manumission, whose livelihoods are from the military class, and who are not registered as anybody's rewe, the daughter of a cavalryman married to a cavalryman, so long as she is currently married to the cavalryman. The legal and fiscal relationship between the military class and the taxpayers, mainly in practice, between timar holders and peasants, forms the main subject of the secular law. This emerged as a body of written codes during the reign, and at the command of Bayezid II. The earliest such code is the law book which forms the preface to the detailed cadastral survey of the Sanjak of Bursa, dated 1487. This lays out the taxes and fines which Sanjak governors and fief holders may collect from the peasants and pastoralists, and the conditions on which the peasants may occupy the land. Its anonymous compiler tells us, in a rather convoluted preamble, that his sources were the customary laws and rules for well-established customary taxes, the Ottoman cadastral registers and sultanic decrees and oppos. In so telling us, he provides an account not only of this code in particular, but of the secular law in general. Its basis was established custom, as recorded in the cadastral registers and modified through royal commands. Another feature of this law book, which also came to typify the genre, is that it concentrates on details and exceptions, without first enunciating principles or explaining terms. The compiler does not, for example, lay out the rules for the inheritance of peasant holdings, but deals only with what had been controversial cases, such as the inheritance rights of widows and orphans. On orphans, the code states, to charge an orphan an entry fine, for access to the land, is a rejected and forbidden innovation. His father's land is treated as heritable property. If the land left by the orphan's father is given to another on the ground that it is not cultivated, when the orphan comes of age, and if he demands the land, it should be returned to the orphan. On widows, it states, a woman should not leave fallow the land of which she has the disposal, so long as she pays tithes and taxes. It is against the law to take it from her. And oppos. The 1487 Law Book of Bursa provided a model for future codes. 38. Most of these were also law books for Sanyaks, typically forming the preface to a district's cadastral survey by listing local taxes and other regulations. The basis of their statutes was local custom which, as the Slavonic, Hungarian, Greek and other non-Turkish technical vocabulary shows, was often pre-Ottoman. 39 The most striking example of the adoption of local practice appears, however, in the law books for the Sanyaks of southeastern Anatolia which Selim I had conquered between 1514 and 1516. The earliest law books for these Sanyaks open with the statement that they are in accordance with the law of Hassan Padishah, a reference to the Akoyunlu ruler of the district, Uzun Hassan, who had died in 1478. The compilers believed, therefore, that they were restating Akoyunlu law, and there seems to be no reason to doubt their assertion, although some individual regulations clearly predate the Akoyunlu period. The format of these law books is to state what the Akoyunlu regulations had been, noting whether they had been confirmed or abolished, and converting the value of money taxes into Ottoman coinage. A few clauses from the law book for Ergani, dated 1518, provide an example, and oppos. And from each household they used to levy 1 day's labor. 1 sheep was taken from each household as festival tax. And from each household, they used to take as termerjic tax, 1 tenge, which is 2 Ottoman akshas. The provisions given above have been confirmed, as they are. And oppos. Much of Ottoman secular law, therefore, had its origin in local practice and the laws of previous dynasties. Nonetheless, despite this diversity, it tended over the decades to become more homogeneous. Total uniformity was not possible, given the diversity of peoples and local economies within the empire, but certain statutes, such as those fixing the rate of the annual tax on peasant tenements, tithes on crops, or incidental levies, such as bride tax, gradually came closer together. This process was not haphazard, although a Sanjak might, in the years following its conquest, have been subject to the laws of the previous regime. The law books suggest that the compilers of subsequent cadastral registers would bring land and tax regulations more closely into agreement with what they regarded as Ottoman law and oppos. Indeed, on occasions this law came into force immediately after the Ottoman conquest. The early registers for southeast Anatolia, for example, preserve the texts of the Akkoyunlu laws of Hasan Padishah, but the registers themselves indicate that, in some areas, the new Ottoman regime levied taxes not according to the law of Hasan Padishah, but according to Ottoman law and oppos. Furthermore, in this and other regions, the new law books compiled during the 16th century at the time of new land and tax surveys, sometimes record a change in the rate or abolition of a tax, on the grounds that the old tax was not Ottoman law and oppos. The notion of a specific Ottoman law owes its origin to Bayezid, too. It was he who, shortly before 1500, issued a command to an anonymous official to compile in a bound volume, and oppos, all the Ottoman customary laws, which are the pole of the good order in the public affairs of all peoples and oppos. The result of this command was the Law Book of 1499-40, which has, as its major topic, the obligations of timar holders and taxpayers in all parts of the empire. In addition, the compiler added chapters which apply only to local groups, such as the Vlachs of the Balkan Peninsula or the Turkomans of Anatolia. The work as a whole is a collage, as well as the clauses which the compiler seems to have composed himself. Others clearly have their origins in sultanic decrees, fatwas, cadastral registers and the law books of Sanyaks. The collection was a success, existing today in tens of copies, and going through several recensions until it reached its final form in about 1540. It provided, for the first time, a universally applicable code of secular law and a source of reference for defining Ottoman law and oppos. Following its promulgation, it becomes common to find in the law books of Sanyaks references to Ottoman law and oppos. In the 1528 law book of the Sanjak of Kütahya, for example, the clause laying out the tax on vineyards and orchards begins, a tithe is taken from the produce of vineyards and orchards according to what is legal in Ottoman law. A clause specifying the rate of the sheep tax, in a 16th century law book of the Central Anatolian Sanjak of Bozok reads, after lambing is finished in May, in accordance with Ottoman law, the sheep and lambs should be counted, and one ox taken per 2 animals. Nothing should be taken in addition. And oppos. Clauses such as these are evidence of the effect that Bayezid's code, and its later recensions had on standardizing the law. Although the services due from timar holders and the taxes due from peasants form the main themes of Bayezid II's law book, the work in fact opens with what were originally 2 independent criminal codes. The first of these exists separately as the opening section in the misleadingly titled Law Book of Sultan Mehmed Khan, an unsystematic compilation, dating from about 1490. The second code, dealing primarily with capital offenses, 41 seems to date from the late 1490s, since it has a clause indicating that the military class now came directly under the jurisdiction of the Sultan and not of the judges. In later recensions of the law book, the compilers amalgamated the 2 codes into one. Criminal statutes also appear, rather haphazardly, in the law books of Sanyaks. The 1487 law book of Bursa, for example, lays down 150 akshas is taken from someone who removes an eye, and 100 akshas from someone who inflicts a head wound that lays bare the bone, and so on. Similar clauses appear in the law books of other Sanyaks. The reason for these penal statutes in the law books is that it was members of the military class, especially the sabashis, who were responsible for the arrest and punishment of criminals, and who also pocketed fines as part of their income. The application of the criminal law was therefore an aspect of the relationship between the military class and the taxpayers. The law books, however, tell us almost nothing about the procedures of the criminal law, more or less confining themselves to listing the tariff of fines and other punishments. It is difficult, therefore, to establish what was the legal process between arrest and punishment, and also whether the penal code in the law book of 1499 and its subsequent recensions were ever, in practice, effective. On the question of capital offenses, Span Downs in the early 16th century states unequivocally that the case had to come before a judge, no Sanjak governor, he writes, for all the exalted nature of his office, can condemn to death without the permission of the judge. A Sabashi arrests the malefactor, submits him to torture and elicits a confession of his crime, before taking him to take his stand before the judge. If he is condemned, the Sabashi puts him to death. An apos. Span Downs' statement confirms what appears in the 1487 law book for Bursa. This forbids the infliction of the death penalty before the miscreant's offenses are proven in the presence of the judge of the region and apos. It is probable, therefore, that, in principle, cases involving the death penalty came before a judge. Practice was probably a lot more variable. References to capital punishment are rare in the records of the judges' courts, and occasional clauses in the law books of Sanjak suggest that governors would sometimes, presumably for their own enrichment, commute the penalty for a fine. The Bursa law book, for example, forbids this practice. A similar clause appears in a law book of 1540 for the Bazulis, a tribal group in northern Syria and southeastern Anatolia. This states that persons meriting capital punishment should be executed. Not a farthing should be taken in lieu of capital punishment. The fact that the same clause appears again in the 1570 law book for Aleppo suggests that it had been disregarded. Money in lieu of execution should not be accepted from persons worthy of capital punishment. These clauses suggest that in capital cases the executive authorities tended either to bypass the courts, or at least to ignore their sentences. Most lesser offenses seem to have been the responsibility of the executive authorities. Certainly cases do occur in the judge's registers, but these usually record only the facts of the case and witness statements, without recording a verdict or punishment. These presumably were the province of the Sabashi. In many cases, however, it seems very likely that the Sabashi or other military authority was responsible for the entire process, from arrest, although this could be the responsibility of communities or private individuals, to punishment, bypassing the courts altogether. In the absence of records, however, this can only be speculation. According to the criminal codes, punishment for non-capital offenses consisted usually of strokes of the lash, fines, or a combination of both. Whether the authorities followed the code precisely is not certain. They must however have levied fines, as these formed part of the income of the military class, and one small piece of evidence does suggest that, at the time at least of its promulgation in the reign of Bayezid II, the provisions of the code were observed. 4. Stabbing. It prescribes an unusual punishment. The offender should have knives stuck into his arms, and he should be paraded in public. Span Downs provides evidence that this did indeed happen, when he notes, if a person draws a weapon against another, the judge has him stabbed in the flesh with 5, 6 or 7 knives, and led around all the public places in this way. An apos.